have a panel that will discuss efforts states have made to adjust to the COVID-19 pandemic. The initial focus will be on the adoption of presumptions in the law. What are they? How do they work? Their potential impact on established systems, and equally as importantly, how they were created. Who better to do this with than two distinguished law professors? We will next focus on whether workers' compensation is the best vehicle or the best system for protecting those who are injured by a viral infection in the workplace. Little did I know when I was trying to put together the ideas for this presentation that one of our panel members was working on an article. Professor Duff, who's with us today, has recently written an article that's going to be published by the ABA on the title of Can Workers' Compensation, in quotes, Work in a Mega Risk World? The COVID-19 Experiment. This article will soon be published. Finally, we will conclude this discussion about a concern I've had in recent months relative to people that we have had come to our company who, in spite of going through the MSA process, meeting with lawyers, signing settlement documents, and in many states attending or participating in a formal settlement hearing, they tell us that they don't know quite what we're doing and how we're controlling their money and what's going on with them on the professional management of MSAs. So if we have time, we will get to that topic. Our program is scheduled for an hour. We have a chat feature built into this presentation, and the panel has agreed to entertain questions while on topic and at the conclusion of the presentation. We will try to save time for questions. In our presentations in the past, we've really been caught up with time. As with other Ametros presentations, I'm assisted today by Melanie Samaron and Melissa Wright. Let me introduce our panel. We have with us first the Honorable John Lazzara. John was a Florida judge of compensation for 28 years. He recently retired from that position. Both of these gentlemen, by the way, have very extensive biographies, and I could spend probably the next 15 minutes going through the biographies. So I've taken their material, worked it down to something I think is workable for our presentation. So continuing with John, he at various times has served as the president of the Florida Conference of Judges of Compensation Claims. He was a member of the Florida Bar Workers' Compensation Rules Committee, and he was on the Florida Bar Standing Committee on Professionalism. He was instrumental in the founding and was elected the inaugural president of the National Association of Workers' Compensation Judiciary and served on their board until 2018. I know that we have some judges in our audience. If you are not a member of this organization, you should be. If you're not affiliated with the organization, you should be. It's a terrific organization for members of the Workers' Compensation Judiciary to share ideas and learn from their brothers and sisters of the bar. John presently teaches at the Florida State College of Law, where he is an adjunct professor. John, is there anything you'd like to add to this introduction?
No, thank you. You stated just exactly like I wrote it, and of all of the introductions I've ever had, I have to say this is probably the most recent.
Thank you, sir. I'm glad you have your sense of humor, John. Also joining us today is Michael Duff. Professor Duff is a graduate of Harvard Law School. Before beginning his teaching career at the University of Wyoming College of Law in 2006, he worked as an attorney in private practice, an adjudication official, and investigator with the National Labor Relations Board in both their Philadelphia and the Minneapolis offices. In addition to his teaching, he is a nationally recognized commentator and writer on workers' compensation, labor, and employment issues. To characterize Professor Duff as prolific would be an understatement. This is a gentleman who writes a lot, comments a lot, and has good things to say in these areas of the law. Professor Duff has authored a workers' compensation textbook that, interestingly enough, is a text that Professor Lazzara uses in his courses. I've gotten to know Professor Duff over the years, and he and I have some common things in our background. He and I we both majored in philosophy when we were undergraduates in college. When you graduate with a philosophy degree, if you have a couple of dollars in your pocket, you can get a cup of coffee. Graduate school has to be in your future, I think. We both worked as Teamsters when we were younger. We both worked before going to law school, so he had experiences out in the real world before law school. And both of our grandfathers died at a very young age because of their work. Professor Duff's grandfather died from black lung disease at a very early age, and my immigrant Italian grandfather died as a result of a catastrophic work accident. Professor Duff, would you like to add anything to this introduction?
That was a pretty good one, Paul. I appreciate it. I guess I'd also say that when I was with the Teamsters, I worked at US Airways, now I guess merged into what will be left of American Airlines when we get through with this catastrophe. And I spent a lot of time as a shop steward when I was kind of out doing blue collar work. And the reason I mention it is that in light of what you were saying in your introductory remarks regarding, problems with complexity and legal systems, it's something that really resonates with me because I've spent a lot of time in my life trying to explain what the heck is going on to working class folks, and it's a challenging problem in the law. Thank you.
Thank you, Mike. I am your moderator. I'm Paul Sighinolfi. I am not a law school professor. I'm but a mere mortal. I am a lawyer with years of experience both as a trial lawyer and as an appellate attorney. Most of my work, the last 25 years of my active practice, was focused on workers' compensation. I was appointed and served as the executive director and chairman of the Maine Workers' Compensation Board, a position that I held until my governor was termed out. I presently work as a senior managing director with Ametros. We are a company that provides the professional management for Medicare set-aside accounts. Ametros has afforded me the opportunity to organize and moderate this presentation. Gentlemen, if you don't mind, rather than referring to your titles as professors, I'm going to use your first names through the course of this presentation. I assume that that's acceptable?
That's good.
Okay. As advertised, we're going to discuss several topics this afternoon. We'll begin with a discussion about COVID-19. COVID-19 was first discovered in China last year. It has been with us in the United States since the beginning of this year. Because it is a virus, the initial focus was in the medical communities, but soon thereafter, it became a concern for legislators, regulators, and governors. The concern essentially was our people are getting infected, they're unable to work, what do we do? Well, a simple solution is to cover exposures at work as a form of occupational disease, and perhaps even make it an occupational disease that's easier to prosecute by adding a presumption. Let's afford the claimants a presumption of compensability. We have an audience that is fairly occupationally diverse. My professor friends here will do what they do best, and they'll help us develop an understanding of how presumptions operate. Michael, if you would, you've helped us with some slides. What is a presumption?
All right, Melissa, you want to advance that title slide there to the first slide? Thank you. So I want to talk, first of all, obviously I'm going to address what a presumption is, and then a couple of other topics that kind of naturally come up along the way is in the context of COVID-19 presumptions. What are they? What do they look like? And the best way to address that is to look at one. And I'll say a couple of words about constitutional limitations of presumptions. When you first hear what a presumption is, one of the things you might think is, well, is that legal? Can that be done? As a matter of constitutional law, it probably can. And then, Paul, I know you were also interested in discussing various ways that these presumptions have been enacted. So those are the things that I'm thinking would make the most sense to sort of touch on here. Melissa, can you advance?
Oh, go ahead. John and I are going to have some questions about, for example, why Minnesota and how these things come about, and presumptions rebuttable. And well, why don't you start?
Sure. Melissa, if you could advance to the first slide. The first thing to keep in mind is that a presumption is a procedural rule. Now, if you're not a lawyer, right, you don't even know maybe what that means. But essentially, you have laws that are what we call are substantive. They're substantive rules. You can't commit a crime and you can't commit a what we call a tort. There are various bodies of law that have rules of substance, right, that we can sort of explain. You can't smack somebody in the side of the head. Why can't you do that? Well, we have a rule about that, okay? Now, if somebody violates a rule and we wind up litigating over that alleged violation, then we have procedures that govern how a case is actually handled in a court or an administrative agency, which is another place where violations of law can be addressed. There are all kinds of procedural rules. How long do you have to do this and how long do you have to do that? A presumption is a kind of procedural rule, and it says something that logically is pretty straightforward, but as applied can be kind of tricky to think about. Logically, what a presumption means is that if somebody establishes a group of facts, let's say you establish fact A, fact B, and fact C, right? The presumption would require whoever's hearing the case, we call that person a fact finder, to presume fact D. So if I've got A, B, and C, something about the law says that I'm required to accept that fact D has also occurred, even though the party who proved A, B, and C has not, in fact, proved fact D. Now, does that mean that that fact that can be presumed, that D fact that I'm talking about, would always be presumed? And the answer is it depends, as it often is in the law. It depends on whether the other party in the litigation, in the case that we're talking about, has some evidence that would say, you know what, I know that D can be presumed as a matter of law, but I've got some evidence here that I think goes against establishment of that fact D. All right, and so we call that kind of presumption a rebuttable presumption. Let me stop there. Paul, does that raise any questions in your mind as I kind of lay that out?
I'll bring in John here. So am I just simply filing something with either a court, or am I filing something, for example, with the Workers' Compensation Board that simply says, I, Paul Sighinolfi, was working at this company on this day and I came down with COVID-19, or is there more to it than that? What's A? What's B? I am who I am. I was working.
Interesting. Right. What came to mind as Paul was speaking is the intoxication and drug use defense here in Florida, where there is a presumption. If you have a certain level, well, first of all, if you're an employee. Second would be if you have a certain level of alcohol in your blood system, or if drug test shows that you're positive, the presumption is that the injury was occasioned by the intoxication or the drug use. So in other words, that would be the fact. It's a rebuttable, if you will, presumption, in that the injured worker can show that that was not the reason for the injury. I'm not sure that answered your question, Paul, but that's the best way I can think of it would be by way of examples.
What's the difference between an irrebuttable presumption, Michael, and a rebuttable presumption?
Well, an irrebuttable presumption is one that you can't rebut. In other words, once we presume, let me give you one of the simplest presumptions I know. I teach evidence at my law school, as well as workers' comp and some other things. If you don't show up anywhere for 5 years, where'd Paul go? Where'd John go? We don't know. They're not around. They haven't been around for a long time. Well, that can cause all kinds of legal problems, as you can imagine. After 5 years, there's a presumption that you're dead. All right, this is one my students get pretty readily, right? So there is a presumption that you may not be alive, you're dead, which means all kinds of things. We might be able to administer your will, all kinds of things that are operative once you become dead may be set in motion. How would you rebut that presumption? Well, I don't know, you show up, right? You showed up. That's a pretty persuasive rebuttal of the presumption that you're dead, right? So there's a good example there, right? And if we think of it in COVID-19 terms, I mean, what we're really looking at is a diagnosis. You've got COVID-19. All right. Okay. If you've got COVID-19, you contracted it within a period of time that's sort of established by statute, by statutory law. We're confident of the diagnosis, and you're a member of a certain group of employees that we've been calling essential employees, although as a matter of law, it doesn't have to be, it can just be whatever employees the legislature designates. If you've got the COVID-19, you're a member of the particular class of employees, there is a rebuttable presumption that you got COVID-19 at work. That work caused COVID-19. All right, and so that's one of the easiest ways to think about that. Now, an irrebuttable presumption would be one in which, okay, we say you have COVID-19. There's a presumption, right? And so confident are we that you have COVID-19 that we don't even want to hear any evidence to the contrary. You've got it, you're covered, work caused COVID-19, end of the story. Now, most COVID-19 presumptions are rebuttable presumptions. In other words, if the employer or the insurance carrier has evidence that no, we can rebut this presumption that we're making, that this person got COVID-19 at work with some evidence that we have, well, then go ahead and you can attempt to rebut that presumption. And then you have what we call the burden of proof to prove that in fact this worker did not obtain or have COVID-19 caused by work. So that's a sort of a shorthand way to think of it for me. That's really what's going on here.
Okay.
Should we look at a statute?
Yeah, you have a statute there for Minnesota.
Yeah, so
Yeah.
Melissa, could you flip to the next slide there?
Paul, I did want
John?
to mention one thing, and Professor Duff generally teaches evidence, obviously knows this. The task with respect to rebuttable presumption is that generally the evidence has to be clear and convincing, which is a harder, or if you will, a more stringent standard than simply what we see in workers' compensation, which is competent and substantial evidence. So in other words, the burden is a little higher, if you will. It's got to be a standard of more likely than not.
So let's have a discussion between professors here, which I'm sure will thrill Paul. Obviously, there are various standards of proof by which presumptions operate. We have what are called bursting bubble presumptions, right? Which are presumptions that are very easy to destroy as a matter of law. If there's any credible evidence in opposition to the presumed fact, the presumption bursts. It's a bursting bubble. It's very easy to rebut. And then there are others that are, as John says, that are may have a higher standard of proof. And in fact, the legislature can establish whatever kind of presumption or standard of rebuttal that it wants. It has tremendous discretion in terms of how it creates these presumptions. Now, John, the Minnesota, you'll see that the Minnesota, we can, if we look at the example here, we'll see how Minnesota does it, right? And now remember, we said that the sort of threshold inquiry of these presumptions is the definition of the workers that are the beneficiaries of the presumption, right? And what we actually mean, we have a diagnosis of COVID-19. Those were, we said, the sort of preliminary inquiries. Well, look at Minnesota's, and John, Paul, you asked why Minnesota. I think that the way Minnesota's presumption is written fits well into their overall body of workers' comp law. And as I look at it, it's pretty easy for me to figure out what's going on in that statutory scheme. Some states have enacted provisions a little harder to read, a little harder to find, a little harder to explain. So that's sort of the shorthand explanation of that.
Let me stop you there, Michael.
Yeah.
Early in our discussions of doing this project, you were kind enough to share with us a breakdown that you and some other professors had put together that showed what states have done and what's going on. So Minnesota is one of multiple states who have addressed this issue. Is that correct?
That's right. And in the chart I provided you, Paul, there are 25 jurisdictions listed. And it's tricky because what some jurisdictions did, and we'll talk a little bit about this, is that they enacted a presumption by executive order, and then they followed up by passing legislation. In at least one case I'm aware of, there was an administrative regulation that created the presumption, followed up by legislation. So it's kind of hard to follow. But as far as I can tell, we've got about 25 jurisdictions. The other thing that's going to get tricky, Paul, in a little bit here, are states that early on enacted presumptions, and we have to figure out what the sunset date of those presumptions are. When do they expire? Have they renewed when we weren't looking? And what's the status of them?
Yeah. So we've isolated Minnesota because it happens to be a pretty good piece of legislation.
It's good in the sense that it's making no sort of, leaving policy questions to one side. It's clear. I can understand it. I understand how it fits into the rest of the statutory scheme, right? So if you notice in the slide, we've got this presumption potentially could apply to various categories: licensed peace officer, paramedic or EMT, nurse, healthcare workers. I'm not going to read them all. Healthcare providers. Sort of interestingly, a person required to provide childcare to first responders and healthcare workers. Right now, you can have we can stop right there and have a discussion about, well, why these workers and not other workers. And I think, John, you asked me in a private note, what makes somebody essential, right? And that's a great question.
Right, exactly. I mean, it's really across the board in terms of who's an essential worker. Everybody thinks they're an essential worker, obviously. Certainly their families do. But the feds primarily use high-risk employees, I believe, and low-risk employees. Generally, here in Florida, there's no statutory provision with respect to a presumption for COVID, and there is no executive order by the governor other than an administrative order, primarily, if you will, or directive from the chief financial officer, which essentially is the insurance commissioner, that in essence covers first responders, state employees for the most part. It leaves out, for instance, cashiers at grocery stores. It leaves out certain other elements that are, or rather workers that generally are out there and have been out there and would be otherwise classified as essential workers. But there is really no protection for those. And the problem seems to be, what is an essential worker? How are these people going to be defined? You have one group that's in, you have another group that's out with respect to the presumption, and it has caused obviously some problems. There are cases that are coming up with respect to some of these issues. Deputy Chief Judge Langham, who heads up the workers' compensation judges here, has an excellent blog, incidentally. If anyone is interested, go to the Florida JCC site. He's got a blog called Florida Workers' Comp Adjudication, as does Professor Duff, a workers' comp blog, if the title is correct, Professor. But in any event, roughly of all of the claims that have been filed in Florida at this point, which dealing with COVID, essentially it comes out to about 30 to 33% of all claims in Florida. That obviously includes not only state workers, and most of those are picked up simply because of the insurance commissioners, or rather the chief financial officer's directive. But most of these cases are in fact being picked up. It's about 40% that have not been picked up. And the interesting part is that a lot of these workers are not necessarily state workers. The breakdown with respect to that appears to be that healthcare workers amount to, so far, about 27% of the claims. Office workers, about 11% of the claims. Protective services, about 32% of the claim, and service industry, 29% of the claim. So in terms of workers, it's pretty much across the board. And definition is a problem. In other words, I guess the devil's in the details in terms of defining who an essential worker is.
Michael, let me make a few comments before I turn it back over to you. There's a website, the National Conference of State Legislators website, where they have gone through a fairly careful analysis of who they think should be considered an essential worker. And it's a pretty broad population. Before we went on the record, I was explaining to both of you, gentlemen, that I was listening to an NPR program on Saturday afternoon where they had a union president from the New York Transit Union who was saying that his people in New York, 120 of them have died from COVID. And I would suspect that in a highly populated area like New York City, like Boston, like San Francisco, where public transit is critical, that the transit workers are pretty essential workers from my perspective. So it seems to me that your definition really might be driven by the population, the work mix that you have in the population working. Michael, I'll turn it back to you.
Well, I think that's right. And let me just say that I think the overall sort of legal issue is the limits of a state's discretion in defining who the state thinks are essential workers. And I think the state has plenary authority to designate whom it wishes to be essential workers. And you're always going to have questions of fairness, which I think we're sort of implicitly talking about, and questions of cost. Because obviously what's happening here with presumptions, when you have a presumption of causation, what you're basically saying is that more workers' compensation cases are likely to result in awards. And John, those numbers in Florida are interesting because I think it's sort of there's a lot of interaction with causation standards in a given state. I suspect that in certain states, if they did not have a causation presumption, you'd have a lower margin of victory, right? And then and so that we're always sort of debating that. Well, what would happen if we didn't have presumptions? Would we have an unacceptably low number of employees able to make out claims? Is there even such a thing as an unacceptably low number of claims? If workers' compensation is meant to do it, we'll get into some of these issues, right? But it's interesting how there's interplay even as you're discussing who's an essential worker. You invariably have these kinds of discussions about, well, what's the overall impact going to be on cost? Is this really what we're supposed to be doing generally, and so forth?
Let's make it clear, John, Michael, though, if I am trying to prosecute a case and I think my client gets the presumption because of the position he was in and the kinds of things that were going on, if the presumption gets kicked out, I still have a right to prove my case on its merits. I just don't have an easier.
That's correct. That's correct. You don't have there are two things. You don't have the benefit of the presumption, and the burden of proof doesn't shift to the other party. Those are the two things that we can say about the impact of the presumption. Melissa, could we move on to the next slide? Thank you. So the last colloquy that we had concerned who's in the pool of eligibles, who is potentially a beneficiary of a presumption. That's what we were talking about. The next subject is, okay, what other prerequisites exist, right? And I think when we were talking about this more abstractly, we said, well, you're going to have designated beneficiaries of the presumption. And then you might also have some other prerequisites before the presumption would spring into effect, right? And so in Minnesota, note the prerequisites. The employee's contraction of COVID-19 must be confirmed by a positive laboratory test, or if a test was not available for the employee, as diagnosed based on the employee's symptoms by a licensed physician and so forth. I think that the intent of that provision is pretty clear. We've got to make sure that the individual who's going to be the beneficiary of this COVID-19 presumption, in fact, has COVID-19, right? That's pretty straightforward.
Well, let me stop. No, it's not. let me go after you here, Michael. What if I question the test? I'm not sure that's a valid.
You misunderstand me. What I'm saying is the intent of the provision is clear.
Oh, yeah. Okay.
That's my point. Yeah, and you can, and actually, the reason that the statutory language is placed in the statute is to sort of define the terms under which we're going to have that fight. Right? Because if we didn't have a provision like that, we don't even know how we're going to have the fight about whether the person actually has COVID-19. Or how about this? When precisely was the individual diagnosed with COVID-19? Or what about the fact that in so many cases, the individual's asymptomatic? I mean, are we compensating mere possession of the disease, or are we compensating disability? So there are myriad questions, right? But the structure of the statute says, hey, look, at a minimum, if you're going to be a beneficiary of this presumption, you're going to have to prove that you've got COVID-19, and here's how we say you do it. Now, an interesting question, Paul, is would there be any basis to challenge even if that provision were satisfied? And I'm sure we've got cases going on out there, and our viewers would know more about that than I do, but I'm sure there are conflicts over things like that. Look at the last bullet point. A copy of the positive test or documentation of the diagnosis must be provided to the employer or the employer's workers' compensation insurer. Obviously, that's a notice provision. So you have to have COVID-19, and you have to tell the employer that you have COVID-19, right? And so this is the structure of the Minnesota statute. Now, once we've established what was on the last slide and what's on this slide, it's only then that the presumption comes into existence, right? We presume that causation of COVID-19 has been established. I'll stop there.
Okay. I think of cases that I've had in my prior life. A copy of the positive test or documentation must be provided to the employer. The last thing in the world you want to have happen is have somebody who's infectious to walk into the employer's office presenting proof that I've got the disease. That's an interesting notice provision, whether you can have somebody give it on your behalf. What do you think about that, John?
Well, that's interesting. In Florida, as far as a notice of injury, it can be either oral or written or in any fashion. I think it just has to be some communication or actual or constructive knowledge on the part of the employer. So that can be done in any numerous ways. Even a telephone call might be sufficient. Of course, you're going to have to furnish documentation in some fashion. And here in Florida, in terms of being tested, it's relatively simple. I mean, for instance, CVS, a local drug chain, provides drive-through testing free of charge. If you have insurance, they bill the insurance. If not, it's free of charge. You generally get the result within 2 to 3 days. Now, of course, the notice provision in Florida is up to 30 days, but I think there's numerous ways of communicating notice.
So, Michael, why don't we talk about how this operates?
Okay. And so, Melissa, I can't remember what my next slide is in my slides. Melissa, could you go to the next slide?
Operation.
All right. So, John was alluding to this, right? That, well, once the presumption is established, how do we rebut the presumption? What is the effect of the presumption? Obviously, if you don't rebut the presumption, and I say if you, I mean the adverse party, who in this case is presumably the employer or insurance carrier, the employer or insurer shall only rebut the presumption that the employee's contraction of COVID-19 is an occupational disease by showing the employee's employment was not a direct cause of the disease. Half of that provision is litigable, right? And that's the way causation provisions are, right? I don't know what direct cause means, right? And my suspicion is we won't know what direct cause means until you get some cases that define what that means. But I think the important point here is that a state has broad latitude how it wants to define how a presumption is rebutted. So a state might enact something like a bursting bubble presumption that I mentioned previously, which is suppose the employer or carrier presents some credible evidence tending to rebut the presumption. In a bursting bubble presumption scenario, that would destroy the presumption altogether. And then, Paul, we'd be back in that situation you were talking about earlier, where it doesn't mean that the claimant's case is dismissed. It just means that the claimant no longer has the benefit of the presumption, and the fact finder can determine one way or the other on the issue of causation.
Yeah. One of the things that always, when I was both in practice and when I was working as a regulator, that used to trouble me about presumptions is frequently presumptions are created in situations where it is really difficult to prove the negative. And I remember talking with members of our legislature about bills that they were proposing that had presumptions in them. John, when you were working as a judge, were there many presumptions that came up in the Florida statute that you oversaw that people would struggle to try to figure out a way to prove the negative?
Occasionally, yes. What comes to mind, of course, would be your what we call here your heart-lung bill dealing with first responders and law enforcement, where there is a presumption that the condition is associated with the work. Of course, there are certain contingencies, such as whether there was a pre-employment physical and whether it showed any problems therein. But I agree with Michael. I think the problem with this particular not problem, but the dilemma this statute presents is the word direct cause. What essentially does that mean? The other interesting thing that I see is that it doesn't say what level of evidence you present. I think in Florida here, the appellate court would find that only competent substantial evidence would be needed to rebut, as opposed to in our statute, most presumptions to be rebutted require clear and convincing evidence, which is a higher degree. So I think something else has to be done. The interesting part here would be, for instance, in the example about a direct cause, if you had an employer where 20 people within that particular industry, for instance, meat packing or the poultry industry here, 20 people were ill with COVID and the injured workers contracts COVID, I think it would be easier to show based on that, especially if there's no one in that injured worker's family that has COVID. And I think, frankly, discovery is so important in these cases ultimately, because it's going to come down to the discovery of what you can obtain. And, certainly that also raises privacy issues and other issues along that line. Yeah. But in any event,
I think part of that too, John. I agree. I think part of that is
I think the problem,
how much we know
is
about
the direct cause.
How much we know about the disease and how the disease is transmitted. Michael, why don't we skip ahead on two of your slides? I'm really interested in the methods of enactment. I like the way that you've broken those out.
Okay, Melissa, can you move to? Okay, that's good right there. Yeah. In fact, I can just say in one sentence what I said in the previous slide is if the question is whether presumptions are constitutional, the answer is yes. Civil presumptions are constitutional if there's some rational connection between the facts established and the facts presumed. And suffice to say that we've had 3 or 4 major U.S. Supreme Court cases on civil presumptions. I don't think there's any question that under the 14th Amendment, these presumptions are constitutional. So I'll just, there you go. I covered that slide.
Michael, I can tell you that this slide on how these things are enacted really sets out the reasons that we're having this presentation today. This is the stuff that has caused me the most heartburn as a sort of a wonk in workers' compensation and somebody who watches these things. What's the best way to create these? What's the way to enact a change to the way you operate? Is it through legislation, administrative rule, or the executive fiat? So why don't we walk through this now?
Let me approach it by sort of addressing what may be the source of your heartburn. It's always a dangerous diagnosis, but you know, there's something about democratic process, right? When we enact a statute, right, we understand that what has happened is that legislators have created a statute, however many houses there happen to be in a particular state. It's gone through a particular process to get that far, and then the governor of the state signs off on the bill, which becomes law, right? And that's what we think of as being democratically a legitimate law. And anytime you have law that becomes law in a manner other than that, you begin to trigger concerns about the legitimacy of the binding rule, however characterized, and whether it's legitimate. Have I touched upon your heartburn a little bit?
I'm feeling good, Michael. Thank you.
Okay, so that's good. And you know, right out of the gate, we had the example. Was it Illinois that enacted an administrative rule that just kind of said we're going to cover with a presumption, a COVID-19 presumption, pursuant to the authority vested in the administrative agency. You know, and when an administrative agency is created, as I know both of you gentlemen know, and most of our viewers, there is a statute that confers specific authority. Here, administrative agency, here is what you can do. And in order to assist you, we've passed this statute that's designed to solve some kind of big social problem. We create an administrative agency to deal with the day-to-day activities of enforcing, administering that statute. And here are the limits of the powers of that agency, okay? And so right off the bat, you had a challenge of the type that I suspected we'd have as soon as I heard about this provision, which is whatever that administrative agency did, it was beyond the scope of the authority of the statute setting up that agency. Every administrative code has some provision like this. Those of you who do federal practice will recognize it as APA 7062C, which says exactly that, and most states parallel the federal administrative statute in that regard. So that's an extremely vulnerable sort of approach that a state could take to try to cover COVID-19. We're going to take the authority that we think that the workers' compensation agency has to do all sorts of things under the workers' comp statute and expand that authority to create this presumption merely because the administrators, the head of the administrative agency says that we can do that. Now, I have to say, I don't claim that it would be impossible to do this, right? Everything would turn on the organic statute that created the agency and how much authority does the agency have. I would say that in most states of which I'm aware, and certainly under the federal statute, I think you'd have a real problem pulling a COVID-19 presumption out of the enabling statute of the agency. Now, my guess is we've got 30 or 40 viewers watching this who have counter examples for me, and that's great. That's what makes this this interesting. So anybody wants to add on administrative rule? Does anybody disagree with me?
No, I agree with you wholeheartedly, and I'll let John chime in here.
No, I agree. And honestly, we have to keep in mind also how these came about. In other words, these administrative orders or directives, if you will. I mean, this was an absolute emergency. It was something you've got to do quick, number one. Number two, for instance, I was speaking about the chief financial officer in Florida with respect to Florida. Primarily, it covers state employees that are and hospital employees also, but state employees. So we're talking about a fund. In other words, the workers' comp claims, it comes out of a state fund anyway. So in other words, there isn't any necessary liability at this point with respect to private carriers. But I totally agree. If it's legislation, it's as Professor Duff stated, it's a slam dunk. It's constitutional, I think. The administrative rules, certainly. The question is whether or not it exceeds the statutory authority. I think a lot do, but
yeah.
I don't think there. And Professor, maybe you know better than I do, Michael, whether there are any challenges at this point with respect to some of these administrative rules.
Well, there was obviously in Illinois, because that rule was found to exceed the scope of the statute. So that was a successful challenge, and Illinois followed up by enacting a statute that was similar in many respects, but also had some differences, the legislation that came out of it. And John, you made a really important point, and I want to stress this because I think well, it's easy to forget it. This is an unprecedented situation. So
right.
When I say, well, an administrative agency, I don't see where they have the authority. It's not like I'm saying those crazy people did something, deplorable or something. It's like, look, we've got something, we've got people sick right now. We've got an emergency situation. It's unprecedented. And I would be really surprised if we didn't have a lot of legal expertise employing creative strategies to try to either to cover people or to not cover people. I mean, this is, you have a lot of swirling policies. It's very complex. And it's a nice segue, Paul, into the executive order cluster of material there, because we've seen,
Yeah, let me do this. We have an interesting question out there, but one of the things I would like to get to with you guys, and it turns out that our topics are much bigger than our time would allow. We have a question. We can see it in the chat. Are most state presumption statutes narrowing how an opposing party may rebut in this way that assumes the validity of the diagnosis per the verifiability of the flawed test? So I think they're asking essentially, how do you go about attacking these when you might have a flawed test? I think you just go ahead and prove that.
Yeah. So Paul, do you understand? So the way I understand your interpretation of the question is that you're challenging the validity of the test. In other words, if we went back to that slide where you have to have a particular diagnosis, there's, I think that you have some foundational, it depends on what the basis of the challenge is, obviously, right? But I don't think you lose, for example, rights to authentication, right? The statute is laying out particular prerequisites, and I'm not aware of statutes that go into more particulars that would make it more difficult for you to disprove the validity of the document. Now, have to be careful here, right? Because all of these things are being litigated right now. And so, it's conceivable to me that something has happened in terms of case law, or even in terms of an executive order that I'm not aware of. But I'm not personally familiar with a statute that makes it more difficult to disprove by traditional evidentiary means the authenticity or reliability of a document.
Let me ask you guys this.
I agree with that. Everything I've read in terms of whether it's an administrative rule, an executive order, or legislation doesn't really talk about, or doesn't address, if you will, the issue of attacking a diagnostic test. Seems to almost assume that, you know, they're taken as a given. Once the diagnosis is made, it's done. It's a done deal. And of course, with respect to a physician's diagnosis, you know, they would generally come in.
Yeah, I attack statutes all the time when I was in private practice, and I thought about this statute, and one of my ways of attacking it, and I'll just make this comment, and then I want to go on to a bigger question for the two of you guys, is what is COVID-19? And some medical people that I've talked to have said to me, what was COVID-19 in March is different than what's COVID-19 today. We've had a mutation, and they think the mutation probably took place in Italy when it was over there. And so what we're seeing now is more, it's a more vigorous virus. That is, it's more easily contractable, but it's less deadly because of the mutation. And so what I would do is say, what do you mean, what is COVID-19? and you know, challenge where's the definition? What are we looking at exactly? But anyway, here's what I would pose to you guys. I know when I was in law school, I had a professor who was a mentor who would occasionally get retained as a consultant for different things. So I would like to retain both of you gentlemen. We have this extremely dangerous virus. It's not COVID-19. It's something 20, because we're coming up to with another number. It's struck the United States. It's spreading through the population. How would you advise me? Let's assume that I'm a governor. What is the best way for me to put together a system that would protect my working people in my state? Do I do it by legislation, administrative rule, executive order, in keeping in mind this is extremely deadly stuff, and we need to get people treated. We need to get them treated quickly. John, what do you do? How would you advise this executive officer?
Okay, interesting question. Well, the first thing you do is you establish a commission or a committee. That's usually what this way you can shift blame a lot easier. But for the most part, that would be interesting. It's a difficult question whether you establish a particular fund or whether it's going to be private in terms of carriers assuming a lot of this burden. You know, I don't think we've actually seen the tip of this. There was something I was reading, as I mentioned, Judge Langham's blog yesterday, and he mentioned something called long COVID, which apparently is a new term for symptoms that arise after supposedly the person's symptoms initially are abated. In other words, you don't see this over the long run. There's going to have to be some sort of
Let me stop you there, John. I had a doctor recently tell me that he envisions that as being much like post-polio syndrome. So those of us who are of the age where we knew some people had polio, years later, they came up with other symptoms 30, 40 years later that were connected somehow to polio. So there's some fear that this might be a very similar kind of virus.
No, absolutely. And a lot of these claims that are being picked up now, where the actual cost here in Florida, I mean, the actual cost of the claim so far with respect to COVID amounts to about 7.5% of the total cost so far for all claims that the Division of Workers' Compensation has reported on, which is really astounding. The point I guess I'm trying to make is that these are cases that may start to appear later. In other words, even though cases are being closed, that means that the person who contracted the COVID, their symptoms, if you will, abated, they've gone back to work. We don't know what the long-term effect is going to be. Paul, in one of our conversations, you mentioned something about scarring of the lungs and scarring, that will appear later. I think this is something that states are going to have to consider. How are we going to deal with these? In other words, in the long run, when they start to manifest, if they manifest themselves.
So, Michael, you're the man of the hour. I'm the governor. I've come to you and said, sir, I've got this problem. Fix it.
Very
Tell me
easy, very easy. I'm advising the governor. It's a very easy question. I would advise the governor to proceed by executive order. Because if I'm advising the governor and the governor says, do I have the authority to do this? I think my answer would be no one knows. and we need to move now. And so that would be that would be the choice that I would make in that situation. Now, you know, if I were thinking more strategically and long term, I mean, I do think that we're going to have some serious questions about, we are having serious questions about the extent of executive power. You know, the extent of, you know, what an executive can and can't do. We know from the steel seizure case, for example, that an executive can't seize steel mills during wars in many instances. There are actually statutes, that's what that Defense Production Act stuff that was in the news not too long ago was all about. There are statutes that can authorize certain actions, but generally speaking, the executive is not bound by the Administrative Procedure Act, right? So, and so is not bound by reasonableness. I would tell my governor, go for it, because we've got a problem before us. And then if somebody tells us after the fact that exceeded your authority, we were covering this, and then hopefully the people that are telling us that we can't do this have some kind of bright idea as to what we do. And sometimes I think that's how you have to act in emergencies. Can I make one point about John's point? I know we're running out of time, but
Go right ahead, Michael. Go right ahead.
COVID long. I was just talking about this with a student the other day who on her own was making an analogy between some of the asbestos causation issues and some of these COVID kinds of things that John is talking about, you know, where we have a long latency period in that intervening time. We have other potential causes. Do we have like the restatement multiple sufficient cause problem that we have with asbestos that in many cases simply have not been resolved? I know people like to sort of comfort themselves that that's all been resolved. That's not resolved, okay? And so you get a very similar situations, and I really think that we're going to have we think we have causation problems now. I think we're going to have maybe even more complicated causation problems down the road.
Yeah, I think the asbestos cases are a very good example. I also think, Michael, the radiation cases. I don't know if you've ever had any radiation cases, but I had a half dozen at one point in my career. And those are difficult cases too, because they have a latency period of 20, 25 years sometimes. So,
Right.
John, you want to add anything to this? That was great insight, Michael.
Yeah, no, I really don't. You know, I didn't answer your question directly, Paul, with respect to advice to the governor, but I would say it should be a legislative route. It should be legislation. I mean, and you have some states that have done this. I mean, you had, I think it was Utah came out with legislation within 8 days, while others took a little longer. But I think legislation is the way to go, as opposed to simply by governor executive fiat.
Well, we saw in California that the governor there originally came out with an executive directive, but now they've gone to the legislature and they've actually got a nice piece of legislation.
I think that's the right approach generally. I think the executive should be anticipating follow-up by the legislation. But Paul, you told me this was a deadly disease, right? And I'm holding you to that, right? So we're gonna issue the executive order right now.
Okay. Well, gentlemen, I think we are just about out of time, and I don't see where we have any other questions. Any final comments, John? Any final comments from you?
No, not really. I think we kind of covered it today to a certain extent.
Michael, final comment?
Just the unknown out there.
Yeah, the one thing I will say is that I have great concerns, constitutional concerns about the potential for categorically denying workers' comp claims and the possibility of tort claims through civil immunity. I think that complete cutoff of a remedy when what you're looking at is arguably wrongful conduct is a real legal problem down the road.
Okay. Gentlemen,
I agree. That's very.
I want to thank both of you. This has been great. John, thank you very much, my old friend. And Michael, thank you very much as well.
Thank you. Thanks for the invitation.
we have done some seminars or webinars recently with some great doctors, some great judges, and then to have you two guys, I'm really blessed to be able to work with folks like you to help us better understand some of these complex legal issues. Gentlemen, thank you very much.
Thank you, Paul.